last, let's talk about the Richard Allen case, and specifically the idea that someone else did it. That's come up from the defense, most famously, at least so far, in the context of the Franks memorandum that they filed, as they outlined an alternate theory of the case, not only based on the crime scene itself, but also pointing the finger at specific other people. And they've continued on that route since they've come back on the case, the defense attorneys. So it's only logical that they're going to want to pursue that if this case goes to trial. It's unlikely to derail the case before the case makes it to trial, assuming it ever does. I didn't think it would derail anything on the Franks hearing because it's not really going to overturn a search warrant. But it doesn't mean, as I've said before, that it's not more interesting in the context of the trial, because that's where the rubber hits the road on this and where you'd want to use this kind of evidence. So let's talk about that. Can you just go into court and say, well, this other person did it? Why not? I mean, if that's your defense, right? Well, one reason why they don't let you do that is because then that's how every case would be. Everybody would be saying someone else did it all the time and just pointing the finger at people. So to stop that, there is at least some tests that go on with that. So let's look a little bit at the general legal framework in the state and see how this operates. It's fairly consistent with how other states do it around the country, at least from what I see. Not going to be anything surprising here. And what factors the court should look at, how you decide whether this comes in or not, if you're going to fairly decide this issue. All right. And fairly deciding the issue isn't, well, I think he's guilty, so he shouldn't be able to say it, or I think he's innocent, so I don't care what he has to say. There should be no legal test involved. He should just be able to say what he wants. It's not really how it's supposed to be. Now, I don't know how the judge will apply it, but in theory, there's the law out here, and you look at the law and you see how it applies to the arguments and the evidence that they have, and you make the right decision, and hopefully that'll be what happens. Let's take a look at what the law is. That's what we're here to do. So again, we're talking about third-party culpability, and there's a difference between the evidence at the scene doesn't point toward my client versus the evidence at the scene points towards this specific other person. So it's one thing to say, well, these things found at the scene are things that you would find with someone else, not my guy. My guy has nothing in common with any of this. That's one type of argument, but it is different to name a specific other person. And I think that was an issue in the Zachariah Anderson case, if you remember that being discussed there. So we're going to get into I want to specifically talk about this other person angle, because that's where the defense is going. They've got names, right, for people who they feel are responsible for the crimes. And the defendant has a right to present a complete defense, a constitutional right to do that. But like everything, it's more complicated than that. And again, I've already said that just because you have that right doesn't mean that you can just say whatever you want. It has to be consistent with the rules of evidence. Let's take a look at that. All right, so first rule that matters, and it generally matters in all these things, is Rule 401, and at least that's how it's styled in most jurisdictions. Relevant evidence, and what's the test for it? The rule says evidence is relevant if it has a tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. That's the test for relevance. Now, how does it apply to what we're talking about? Well, the Indiana Supreme Court has been pretty clear on that, by saying evidence of a third-party motive tends to make it less or more probable, well, less probable that the defendant committed the crime, and is therefore relevant under Rule of Evidence 401. That's pretty straightforward. Rare is something in the law so straightforward as that. Evidence of a third-party motive makes it less probable that the defendant committed the crime, so it's relevant. So we can stop the video now, right? Of course not. It's going to go a little longer than that, because we got to get into the weeds here to know how this actually works. And if you watch trials much, then you tend to see what is called a Rule 403 motion or balancing test or objection or this, that, or the other. Just because something's relevant doesn't mean it comes in. And look at the title of this rule: excluding relevant evidence for prejudice, confusion, or other reasons. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following. Unfair prejudice, that's where it comes out a lot. Maybe it's slightly probative that the defendant did some other terrible thing, but it would really prejudice the defendant. The probative value is slight. The prejudice high, you can be kept out. It could confuse the issues, mislead the jury, and do delay, or it's cumulative. So those are reasons the court would say, well, it may be relevant, but I'm going to keep it out. And here's what the state Supreme Court has had to say on this subject regarding third-party culpability. This evidence may be excluded if its probative value is outweighed by unfair prejudice, confusion of the issues, or potential to mislead the jury. Rule 403. In the context of third-party motive evidence, these rules are grounded in the widely accepted principle that before evidence of a third party is admissible, the defendant must show some connection between the third party and the crime. Well, what does that mean? Some connection between the third party and the crime. That's going to mean different things to different people, right? So you have to look at some of the case law, things that have been decided there to see, well, how do they frame this? How do they shape this? What does that mean that some connection? And sometimes it's said to be a direct connection, a material connection, something like that. So let's see how they've decided it in past cases. Let's see. Get the right button will help me move that along. All right, we're going to look at some of their cases here. The Joyner case in 1997. Here was the evidence the defense wanted in. A third party, not the defendant, the person who they wanted to blame for the crime, was having an affair with the victim, worked with the victim, had sex with the victim. Actually, I think it was the night before the disappearance, argued with the victim the day of disappearance, and the day after disappearance was late to work and falsified a time card. More than that, there was a hair sample found in a bag that was put over the victim's head that excluded the defendant and the victim, but was a 99% probability match to the third party. That's what the case reported. The court said, listen, that is sufficient connection to the crime. So if the court excluded that, which they did, that's not going to be allowed. That has to be allowed in. This could show the motive and opportunity of this third party. That's enough that the defendant needs to be allowed to present this to the jury, and then let the jury make the decision. So there's a case there of some facts where the court said, if you're going to bring in this type of evidence, that meets the test. The court needs to let the jury consider that. You need to be able to present that evidence. Let's take a look at another case. Lashbrook, this is in 2002. The defense evidence was that the third party said the victim was going to die, and according to a witness, said it 3 times. So the result, the court said there was no material evidence that the third party person was actually connected to the crime. You didn't see anything in the discussion of the case about somebody seeing the person at the crime scene or near it or something like that. And plus, the jury heard that this lead had been looked at by the police in the aspect or in consideration of an incomplete police investigation. So the court said not letting that witness testify about that and then pointing the finger directly at this third party person wasn't reversible error. It could be excluded. So yeah, you need some kind of connection to the actual crime and not just somebody who was agitated at the person. Now, obviously in Joyner, you had a lot of that, right? A lot of that potentially, at least. Okay. Well, why do I have Joyner on that? Sorry, I've got the wrong case name, but it's a different case. Trust me, I was copying and pasting some of the stuff. So in this other case, the defense evidence suggests that someone from the victim's past had a motive, a third party. And there were hearsay statements that the victim worked at a Florida bank that laundered money. And there was double hearsay that this was in Indiana, that there was a Florida license plated limo near the defendant's home the day of the murder. So those are your 2 things right there, right? Well, the court said, listen, there's no competent testimony regarding this whole Florida situation thing, and there's no evidence connecting the bank and the limo to the murder. So you need to connect the limo maybe to the bank and the bank somehow to the murder. But the fact that somebody with a Florida license plate happened to be somewhere around the area and this guy worked at a place in Florida, that's all speculation and it's not enough. It's certainly not like the actual Joyner case, right? See, when I got the names of these cases right the way I cut and pasted them. But it's not as extensive as that, although, well, I don't even know if it's good as Lashbrook, where at least a specific person said that guy's going to die 3 times. So in this other case, you can see that it wasn't very close, and they said, now we're not going to let that in. Let's look at a couple more. Hit the right button. Robertson was an Indiana Appeals Appellate Court unpublished decision in 2012. The evidence from the defense was that a third party agreed to take a polygraph because they'd been identified as resembling the robber. And the person said, when the police said, well, if you don't come here, then we're going to think you did it. And the guy said, you know what? If I don't show up for it, then I agree. You can assume I'm guilty. The third party appeared for the polygraph, but the police said, well, we got to reschedule it. So this guy didn't do that. So should you assume he's guilty? Well, police ended up doing a follow-up interview, but not a polygraph. And they thought they cleared this person. And again, the witness said this person, when in a lineup, resembles the robber. Didn't say, hey, that is the person. So the Court of Appeal said, look, there's little value to show that this means the defendant is innocent. These kind of statements together and excluding this evidence was upheld. It sounds kind of reasonable, doesn't it? I mean, maybe not if you think everything should be able to come in for the defense, but in terms of the context of the test, that there's some direct connection to the actual crime. Where was it, right? So there was another case called Allen. It was in 2004 at the appellate level, not the Supreme Court. The defense evidence was the third party person. Now listen to this one. They cased the site. A witness saw the third party coming from the store, which was the scene of the crime, and the person said, I got money and people got hurt and killed in it. Showed a handgun similar to the one that was used at the crime, said it was dirty, which in the context meant that it had bodies attached to it, and then saw this person throw the handgun into a river. And the court said, look, that's enough right there. That's enough to show a connection to the crime, and the defense should be able to put this evidence forward. It is exculpatory, unique, and critical, they called it. Definitely some kind of connection to the crime there, because you have this person saying they did it and actually being seen coming away from where the crime scene was, a weapon, throwing a weapon away and all that. So that's a lot, right? So the defense was allowed to put that in. Let's take a look at this other case, McGaha, Indiana Appellate Court, 2010. The defense evidence was, hey, a third-party drug supplier killed the victim due to non-payment, right? They were mad that they didn't get paid for the drugs, and then framed this poor defendant, someone named Sam. Result, the court upheld excluding this evidence. There was nobody with firsthand knowledge of this Sam person, nobody with firsthand knowledge of any debt or opportunity of Sam. And in fact, there was some indication that Sam was simply a creation of the defendant to try and put pressure on the victim before the crime actually occurred. So the court said, look, if we don't have somebody who can actually talk about knowing this person or connect them to the crime, I'm not going to let you put a fantasy in front of the jury. The Court of Appeal said, yeah, that's right. Let's take a look at the Tibbs case, 2016. The defense evidence is a third party had been indicted for the victim's murder, right? The victim had said to somebody, that person, the third party person, will kill me if I disclose the sexual abuse that I suffered at the hands of that person. The third party asked somebody to clean out his car and made inconsistent statements on the night the victim disappeared. The Court of Appeal said that's not enough. Okay, so now this one had to be reasonably close, right? But not enough, okay, because the third party actually testified in the case about some things and admitted making inconsistent statements, so they couldn't bring in more cumulative stuff. Wasn't a need for impeachment there. And they said this isn't the kind of case that you had, say, in the Allen case or something like that, where it was this direct set of facts connecting somebody to the crime, that that's not enough, that the court could exclude this evidence. Now, the trial court could have decided to let it in. It wouldn't be reversed if it had, but the issue here was the defendant appealing, and the Court of Appeal said, no, we're gonna say it's okay to keep this out. Okay, it's not enough to say that this person was connected to the actual murder. There's nothing there to the scene or the site or something like that. Maybe this gives you a little bit of a flavor for how you should look at these cases. And let's talk about it in the context of the Allen case. Pull this up so I can read it too. So let's apply it to this case. Now, there's the idea, obviously, in the Frank's memorandum, and the defense is going to go with this, as they should, that the scene isn't consistent with Richard Allen. Now, that doesn't necessarily mean that you're blaming a specific other person. So this really shouldn't be controversial, right? Their idea that the scene indicates something that a single person couldn't do, that it was more than one person, and they're going to try to make the claim that it was X number of people at least or whatever, and that if that's true, then those people in theory might have been communicating with each other. Certainly they should have some association or whatever, and the defense is going to say Richard Allen is not known to have association with any other criminal that would have anything to do with this, so he's not likely to be one of that group of people who did it. That's a theory, right? The symbols at the scene that they say were there, they're going to say, look, that represents this type of belief or whatever, the Odinism thing, which we'll talk about more specifically. And that Allen's not known to be connected to Odinism, so why would he have done that? How would he even known to do it? Isn't it more likely that someone else did it, not necessarily a specific person, but someone with a connection to Odinism? This stuff doesn't point to Richard Allen, they're going to say. So that's, I think, the idea of the scene not being consistent with it. They're certainly going to attack the police investigation and ask about, did you follow this lead, that lead, all these tips. The idea that Allen called himself in for being present years and years before, and they didn't get a follow-up until recently, right? So what about all these people in the meantime? What about this and that? That's all gonna be attacked, I'm sure. But let's get to the specific thing, which is the third parties. Let's hit this. So the two people they're mentioning specifically, and that may change to somebody else or whatever, because they open the opportunity for minions. But look, I think you can see from the other cases, you'll have to do better than minions. Now they do cite some specific people, but then you gotta bring that connection together, right? So what's the motive for these people to kill these girls? I know that, the Odinism thing is associated with white supremacy, and certainly in prison it can be and is, and probably potentially in other contexts too. But what's that got to do with this crime? What is the white supremacy angle got to do with this crime? I think that's kind of a red herring in this context. And I know there are some speculations out there, but that's all just pure speculation. So if you can't show how this crime had something to do with that, that's not going to connect anybody to it. I mean, the victims were white. Okay. Now, more reasonable is the idea that there was a ritual involved, because at least according to the defense, it's, we really don't see all the documents at this point. So all of this is subject to actually seeing evidence later in the case, that they say even the police thought that there was a ritual involved in this. There were religious beliefs of some significance connected to the crime scene. So if that's true, and these people are a part of that group or whatever, then maybe potentially you could establish, this motive to create this sacrifice, and these people were in this specific group that did it. I'm not saying they're going to be able to do that or not going to be able to do it, but isn't that kind of the motive angle? Maybe you can think of something else too, and that might be connected to what I'm about to talk about, which is connection to the victims. So you can't just have this, person who has a not terribly popular religious belief that may have some bad things about it floating out in the ether and go, well, let me talk about them because they're going to sound like bad people, so let me just bring them in. You already know you got to have this connection, right? That's what the law requires. So what's the connection to the victims? Okay. Maybe there's a connection to one of the people they're talking about and one of the victims in this case, allegedly, having a son potentially maybe be a boyfriend of one or something like that. There is maybe at least some connection. Like these weren't just random people in the whole world, that they actually were known to the people that they're trying to name out, who they say, well, these people had the type of religious belief to conduct a ritual sacrifice, and they knew these girls or whatever. Okay, so, you're trying to build this logic, but the last piece here will connect them to the crime then, right? And that's going to be the crux, I think, right? Because first of all, if they're connected to the crime, these other things become less important, although they are still important. But critical is to connect them to the crime. Is there evidence they were there, that they were in the locality around the time? There's not really a lot of evidence that we know of pointing to a particular person. There's no DNA of somebody that we are currently aware of that can be identified, not even of Richard Allen, right? So what's the evidence that these people were at the scene? And if not on the bridge, one of them, because it's just one person, at the scene of the murders. So where's the evidence of that? And I know the defense tried to argue in the Franks memorandum that, maybe this person falsified their time card or whatever. Maybe they had their minions do it. The minions doing it, you're going to have something for that. And they have a little bit of evidence for that in terms of somebody saying, well, I was involved in this and that sort of thing. So I'm not going to say that they can't build this connection, and I'm not going to say that they can, because I think, unfortunately, at this stage of the case, the best arguments of both sides are not available for us to see currently, because so much of the evidence is, to the degree it exists, is still not public. It gets lied about a lot, with people saying they've seen this and they've seen that, and maybe they've seen something, or a few people have, but there are more lies out there than truth when it comes to non-public things. So as this case gets to trial, the defense may be able to make this case more strongly, or the prosecution may be able to say, because they really haven't answered all of this in any substance, that these people were cleared because of this, that, or the other. This guy couldn't have been there, because of this time card or this video or this statement, and they have no evidence he was there, so he's out. What about this other person? That ought to be probably a pretty big debate, a pretty big motion in limine. So you might look at the Franks memorandum and think, well, that's going to be a battleground later on if the state wants to try to exclude this and the defense wants to put it in, that we want to be able to present, Judge, the theory, an alternate theory of the case, that not just that the evidence doesn't point toward our guy, but these other specific people did it. So it's obviously critical in a case to be able to do that, because if you can give the jury a plausible explanation for someone else to did it, maybe equal to what you think the evidence shows against your guy, if not more compelling, then that increases the odds of a not guilty verdict, of course, right? So this is going to be really important. And I know there'll be people who think, well, they don't deserve to let it in. There'll be other people say, well, they absolutely do deserve to let it in. Kind of curious on the reasons of all that, because it depends on how you, I think, it's filtered the evidence through your mind at this point. And I guess I'm going to punt on that, because I think later on we're going to learn more about the evidence and we'll have the arguments put in their proper context. But when that does happen, at least maybe you'll know from this, well, this is the kind of test that should be employed to see whether this specific person can be named as the perpetrator by the defense in the trial. It's not completely unfettered. It's up to the judge to make the decision based on this case law and these evidence rules. And we've gone over some of the cases that show how it's been touched on at the appellate level before. And we will see how this comes out. I think if this case goes to trial, it's going to be really critical to see about this, because the defense has really named these other people and said, look, these are the people connected to the crime. Not maybe, but these are the people connected to the crime. And they could abandon that. Absolutely, they could abandon that. But if they don't, then this is going to be the fight here, I think, that we'll see before trial of a big piece of evidence. So, well, that's it for this one. Thanks, bye.